This is attorney Andy Marcantel and attorney Marc J. Victor. We are the Attorneys for Freedom, and you, my friends, are listening to the Peace Radicals podcast. How you doing today, Marc?
Good, man. Busy weekend. Lots of stuff going on. I had a big meeting about running for U.S. Senate this weekend.
Yeah, I heard something about that.
Yeah. So that's in the works, and I had to summarize my entire book into a 2,000-word article, so I think I got that done as well. And, lots of meetings, lots of things going on. So, every weekend now is a live and let live weekend for
Heck
me.
yeah. Well, happy Monday, brother. I think we should start out on the subject of live and let live. Maybe somebody's clicking on this video for the first time. They're not familiar with our podcast, and they're not familiar with what this movement's all about. So why don't you just summarize it in 5 minutes or less? You've already had to summarize it in 2,000 words. Try 5 minutes or less.
Bam, huh? Okay, well, so Live and Let Live is the world's only global peace movement. Hasn't kicked off yet, starts in March of 2023. So we are in the pre-launch phase. Right now, there are chapters really all over the world, lots of them in Africa, a whole bunch of them in Europe and in Canada and in the United States and in Australia. So things are moving along. Who would have thought? People love the concept of live and let live. So what is live and let live? Well, it is exactly what it purports to be. It's how do we arrange the rules of the world such that we can live and let live in freedom and in peace? And so you got to figure out what live and let live means. We're going to have lots of rules are going to be needed to explain really the border between you get to live, you're in charge of your body, property, money, and time, but you got to let other people live as well. They get to be in charge of their bodies, property, money, and time. And we got to figure out where that line is, where one is sort of trespassing on another's right to live. And so we call that the live and let live legal principle. And basically the rule here in this area is don't be an aggressor. That's the concept. Don't aggress against another person's right to control their body, property, money, and time. And so what does it mean to aggress? Well, don't initiate force. And when I say initiate force, this is sort of relevant to what we're going to discuss today, because contrast that with responding to another person's initiation of force. That's called self-defense. You can definitely do that. That is not prohibited by the live and let live legal principle. But initiating force definitely is. Force against any person or their property. Also fraud and coercion, or also doing anything that creates a substantial risk of harm, or you might think of a grave risk of harm or a grave threat of harm to another person or their property. All of those things are aggression. Don't do that. And so any law that is consistent with that overarching rule, don't be an aggressor. Everything we pointed out here, laws against murder and rape and robbery and burglary and theft and trespassing and fraud, those are all consistent. That's what the law should be. If you do any of that stuff, you're breaking the law. That's what we're saying here. But if you're not doing that stuff, well, then you should be left alone. So then there's a live in, oh, by the way, I should mention, we feel very strongly, we're post-racial here. So this rule should apply to everybody. We don't care what color your skin is or where you're born or what your ethnic background is or what holidays you celebrate or what your religious views are or aren't. Don't care. This rule applies to everybody. Even if people form groups, as they often do, right? People sometimes form small groups or big groups. Just because you're a group doesn't mean you get to violate this rule. That goes for corporations and the biggest group of all, the government. Yeah, we're saying it. The government, neither the government nor a corporation should get to violate the rule against aggression. That's the legal principle. The ethical principle is a different matter. We like to summarize that one by saying, look, just be a good human. In this space, you're free to completely ignore us. You can completely blow off the ethical rules, and you don't have to be a good human. You should be allowed to act any way you want, so long as you don't violate the legal principle. But what are we saying with the ethics principle? What do we mean by be a good human? Well, there are lots of ways to sort of explain and offload this. We throw a few things out there like try to be open-minded and be tolerant towards how other people live, legally tolerant towards other people and how they live. Be voluntarily kind towards other people. Help those who are less fortunate, and try to act in a civilized way. If it's okay if we disagree on things, let's do it in an agreeable manner. But the important takeaway here in the ethics world is you're free to violate these rules. We're trying to inspire people. We call these the aspirational values. You're free to be closed-minded and intolerant and uncivilized, and you should be legally protected. You can even be a white supremacist if you want, so long as you don't violate the live and let live legal principle. You're not a member of the live and let live movement because we're pushing aspirational values, which are not consistent with being a white supremacist. But in a free country, you're free to believe whatever you want. So that's what the live and let live movement is about. And we want to say enough of the R's and enough of the D's. We need to generate and sort of coalesce around this fundamental principle so we can organize the rules of the world in a way that we can really optimize human happiness and minimize human suffering so we can get to freedom and peace.
All right. Well, we don't have a guest today, Marc.
That was about 5 minutes.
I think he cleared the 5. We don't have a guest today. We usually have a guest, but the reason we don't have a guest today is because you and I have been asked to talk about Rittenhouse. The Rittenhouse verdict is in. He was acquitted on all charges, and a lot of people have asked us, from clients to friends and family to people sending us messages. They want us to weigh in on this verdict and what we think of the whole thing. So I think that we are particularly well suited for this task for 2 main reasons. Reason number 1, if you know anything about our law firm, you know that we do gun crime cases all the time. We do self-defense cases. We take cases to trial regularly, and gun crimes are very, very much our bread and butter. You want to say a little bit more about that? I mean, our affiliation with Crossroads and giving talks on these issues all the time.
You'd be very hard-pressed to find more well-known sort of, you might call us pro-gun attorneys. That's what some people call us. I don't really agree with that title. It's not that we're pro-gun. I give a talk for probably the last 20 years at the Crossroads of the West Gun Show that I entitle Legal Rights and Responsibilities of Gun Owners. So no, we don't take the position that anybody should have anything they want. If you're a responsible gun owner and you don't violate the live and let live legal principle, well, then you should get to do whatever you want with your property. If you're not competent, if there's a problem, a reason why you might be a substantial risk with a gun, what kinds of those things, what kind of reasons might we be looking for here? Say you're a convicted violent felon, you're somebody who has shown through your past conduct that if you've got a gun in your hands, you're a substantial risk to other people. That kind of a person shouldn't have a gun. There probably should be a procedure so they could petition a court some point down the road to say, look, I'm no longer a substantial risk with a gun. Also, competence, right? This is why we don't allow 4-year-olds to have guns. They don't have the mental competence. There could be adults who don't have the competence, the mental health issues. They shouldn't have guns because they're a substantial risk with a firearm. And then the final category, probably there are some weapons out there that you should have some education about and know how to use properly so you're not a risk of maybe a misfire or something else. You need to know how to properly store a weapon. If you're not capable of storing the weapon safely, using the weapon safely, then you become a substantial risk to another person. You violate the live and let live rule. So that's just a little bit of how maybe the gun issue would apply with the live and let live rule. But yeah, we talk about these issues all the time. I've been commenting nationally on self-defense cases for many, many years now. And so, yeah, this is just really for us, this is another day at the office.
Both of us have been to multiple gun shows and given talks to people, to gun owners about these issues, self-defense and everything. Now, granted, it's in Arizona and Hawaii. We've been, we're certified to practice, but self-defense statutes are more or less pretty identical throughout the United States. There's some nuances, but all the same principles that we teach on are going to be present in this case.
I don't know how many people we've represented in gun crimes, but in my almost 30 years of being a criminal defense lawyer, I'd be willing to bet somewhere between 700 and 1,000 cases involving some aspect, maybe even more, of a firearm, whether it's a state charge or a federal charge. We've done an awful lot of these cases.
Yeah. The second reason, Mark, that I think that we are particularly well suited to analyze this case is because we do not suffer from the mental issue of blind affiliation to political parties.
Absolutely.
As you just heard, Mark, if you've watched this podcast, any episode of this podcast, or seen anything that we've been up to in the Attorneys for Freedom law firm and in the Live and Let Live movement, you might have heard Mark say kind of this dismissive moniker, the R's and the D's. And what's really sad, if you look at outlets that are commenting on this case, before you even click on the link, before you open the web page, depending on what news source it's from, you can reliably predict exactly what their opinion is going to be about the verdict.
Yeah, and I think, just as a side note, this is our fault. We're the consumers of this kind of news. If we don't complain and say, look, if you're going to bring on two talking heads, they should be radically opposed to each other, not on the same page. We're not looking for an echo chamber. But, if that's what people want, that's what they're getting. So we don't care about the echo chamber. We don't care. Look, if people agree or disagree with us, that's fine. We're open-minded. If we get something wrong and there's evidence to the contrary, happy to change our opinions on things. So we have absolutely no interest in trying to make Kyle Rittenhouse look good or bad, or anything about the protesters, good or bad. For us, it's just a dry legal analysis. That's what I don't care what color anybody's skin is. Don't care who's affiliated with what political organization. Don't even care what the motives are, right? Motives are not elements of crimes. It might be important to know what somebody's motive is to try to figure out what their intent is in their head. But as prosecutors often point out, they say I don't have to prove motive. Motive's not an element. So there's a lot of irrelevancies floating around.
A lot of
irrelevancies.
Case. We should flag them as we go.
Yeah.
Maybe we should start. I mean, this is a big topic. Maybe we should just start with some general words on self-defense. I see you have the Self-Defense Statute there. We could read it. We could explain it. What's your preferred approach?
I think we should talk about it generally, just for a moment, at the 30,000.
A couple bright line rule type things.
Why do we have self-defense in the first place? I mean, look, we like to settle disputes in court. The preference is not to settle disputes with any kind of violence, but to say if you've been wronged, you don't get to engage in vigilante justice. If somebody steals something from you, you don't get to chase them down there. I mean, well, maybe if it's going on at that moment, but if they stole something from you a few days earlier, you don't get to march over there and barge in and take it. You got to go to court because we like to settle disputes peacefully. But there's one category of cases, self-defense type cases, where this isn't an option because we don't have the luxury at the time there's an imminent threat of death or serious physical injury, which is what you generally need to threaten or use deadly physical force. There's no time to say, hey, let's go to court. So we got to establish some rules for right there on the street when somebody can use force. And the general rule is, like I said, with the Live and Let Live legal principle, don't be an aggressor. Aggression is already a crime. These are victim crimes in the criminal code. So if you are an aggressor at the time, and this is always analyzed at the moment of the action, right? So if you are an aggressor, then sorry, you don't get to act in self-defense. If somebody else is an aggressor against you, well, then you get to defend yourself, but you don't get to use more force than is reasonably necessary to repel the attack. So just generally, if somebody's just trying to punch in the face, they don't get to do that. You get to defend yourself, but you don't get to pull out your AR-15 and blow them away. Why? Because you're using too much force in response. So to try to characterize this, if we're talking about the kind of force that could kill another person, deadly physical force, then we've said in the law, in pretty much every state, Arizona and Hawaii are almost opposite ends of the spectrum, and yet they agree on this point, which is that the force that is being used against you, first of all, must be imminent. It's a right now kind of thing. It's not the kind of thing where, tomorrow somebody has threatened to do this or that, or even 5 minutes from now, someone has threatened to do this or that. In order for it to be justified, it's got to be right now. The word we use in the law is generally imminent. And then the second thing is, the kind of imminent threat that exists is something that's likely to cause death or serious physical injury. So what the law says, look, if you're going to threaten deadly physical force, it needs to be that kind of a serious threat that is stacked up against you. And a reasonable person must perceive, like, first of all, the actor must himself perceive that, yeah, I could be at risk of death or serious injury, and that has to be reasonable. A reasonable person, somebody who's just a sort of a normal member of the community, if they were in that circumstance, they would agree, yup, this person is at risk of either death or serious physical injury. So that's sort of the framework for using deadly physical force.
That's an important last point that we should pause on real quick, because I've seen some misinformation and confusion about this. So it centers around the reasonable belief. The person has to have a reasonable belief at the time that they pulled the trigger. We're going to keep bringing it back to the time that they pulled the trigger, because there's lots of irrelevant stuff that doesn't have to do with at the time the defendant, in this case Kyle Rittenhouse, pulled the trigger. But very importantly is the way that it's phrased. He's got to reasonably believe it. That's all that's required for him to act in self-defense. Now, think about what this means. This means he could be mistaken about whether or not he's in imminent risk of death or serious physical injury. He could have a reasonable belief that he is, for example, but be completely wrong on that fact.
That's right.
All that is required is that if a reasonable person was situated in his position, they also would have thought it was reasonable to believe that they were in that imminent harm. So that's a really, really important point that people need to understand about self-defense law, and that's going to be consistent throughout the country.
Yeah, another point I think that's important is there's a difference between what the requirements of the law are, which is what we're talking about, and what's smart thing to do.
Yes.
Right? A lot of people get these things confused. It may not have been smart, and probably wasn't, for him to get anywhere near this situation. Just like in the Trayvon Martin, George Zimmerman case, it probably wasn't smart for George Zimmerman to be chasing through the streets after Trayvon Martin. So that's a different question. And something I advise when I speak to groups, and things like we talk about you have no duty to retreat in Arizona. That doesn't mean that the smart thing to do is to retreat if you can in complete safety. So those are different questions, right? Whether it was smart for Kyle Rittenhouse to get anywhere near this thing isn't. In fact, we can say with pretty good certainty that wasn't smart at this point. I'm sure if he had a do-over, he would say, you know what, I probably just steer clear of this whole thing. But that's not relevant to the self-defense question. The self-defense question begins with, at the time he pulled the trigger, did he reasonably believe that his life or a serious physical injury was imminently being threatened? That's the question.
One more really, really important thing here to keep in mind is that the state has the burden of proof to prove that he did not act in self-defense beyond a reasonable doubt. So let's take a moment and acknowledge this. This is so important.
I'm glad you brought it up.
So important. This isn't a question of, do you believe that Kyle Rittenhouse did not act in self-defense by like 60% or 51% or 70%? It has to be, the state must have proved to those jurors beyond a reasonable doubt that he did not act in self-defense.
Yeah, let's fill this out a little bit for a moment.
It's intentionally supposed to be weighted against the government.
Yeah, so the law used to be, and still is in many places, something we call an affirmative defense, which means that if you're a defense lawyer and you are in a criminal case and you want to raise self-defense as a defense, you got to prove it up by what we call a preponderance of the evidence. That's what we call an affirmative defense. The defense needs to prove that the person acted in self-defense. That is not the law in Wisconsin, nor is it the law in Arizona. The law changed in Arizona during the time that I've been practicing. And it's a very important change because now, not the defense having the burden, the state has the burden to prove beyond a reasonable doubt, the same high standard, that the person did not act in self-defense. So what that means is, if you're on the jury and you say, look, I really can't say if the guy acted in self-defense or not. I can't tell. I don't know. That's a not guilty because what you're saying is the state didn't convince me beyond a reasonable doubt that this was not self-defense. So that's a very important fact.
Notably, even if that juror is struggling and saying, I think Kyle Rittenhouse probably didn't act in self-defense. That's a not guilty.
Right. I think it's probably true that he didn't act in self-defense. That's a not guilty here.
Exactly. Yeah, this is an important concept people need to understand. There's important reasons that this is the way that we structure the burden of proof. There's important reasons we put this burden on the state. We'd rather 10 guilty people go free than send one innocent person to prison for the rest of their life. That's what the criminal justice system is based on.
Yeah, I think reasonable minds can differ on whether a defendant ought to have to raise and prove by preponderance the affirmative defense of self-defense, or whether that burden ought to be on the state to disprove, to actually prove a negative beyond a reasonable doubt. The reasonable minds can disagree, but that's the law in Wisconsin in this case, same as Arizona. The state has the burden to prove beyond a reasonable doubt that this was not self-defense.
Sure, and then just final bright line rule that's consistent in every jurisdiction in the United States. You may never use deadly physical force merely to defend property. You never get to do that, and there's some talk about it in this case will probably come up in our analysis. All right, any other big bright line rules we need to throw out there, or can we finally hop into the facts?
There is this question of provocation, right? And so, because I think some people say...
It came up at the end of the trial. There's a lot of talk about it.
Yeah, I don't know if you want to talk about that here or later on in the facts.
I was going to talk about it in the facts, but we might as well just start with it, right? Because provocation, the question here is, okay, as Marc mentioned earlier, if you kind of create your own trouble, you're not allowed to ask for a self-defense instruction. You can't claim. If you're the aggressor, you can't claim to use self-defense.
Yeah, and the law is clear in Wisconsin, just like it is in Arizona, that even if you are the initial aggressor, you are the person who provoked it, there's a way for you to regain your right to self-defense. You got to basically stop being the aggressor and then communicate, hey, look, man, I'm done. I'm no longer the aggressor, which you might communicate by, say, running away, right? At that point, you do regain your right to self-defense. So I think that's an important point. I don't think on the facts of this case that there's probably enough evidence to say Kyle Rittenhouse actually provoked it. But even if you could say that, I think it's not fatal to his claim of self-defense because he's running away at the time this incident's occurring.
Yeah, let's talk about what provocation is not, because the question here that I think a lot of people are getting confused on is how attenuated does the provocation have to be? There are folks in the media saying he provoked this by traveling across state lines and going to Kenosha where he didn't live. That was the provocation that they're tied. He brought his own trouble amongst himself.
That's clearly not provocation, nor is it provocation to simply be carrying even a big scary AR-15. That is not provocation. That's the Second Amendment. As long as you're not a prohibited possessor and that weapon is not prohibited, which it was not in this case, you have a right to carry it down the street, and he did. And that's why the police, upon seeing that, left him alone, because he was not violating the law. That is not provocation. Having a gun, even carrying it, displaying it, even in the midst of a time when you probably would want to have a gun, where there's a riot going on and chaos going on, that is definitely not under our laws, nor should it ever be provocation. That's not what we're... Provocation is when you get in somebody's face and you say, I'm going to punch your face, I'm going to...
Exactly.
That's provocation.
Yeah, it's like it can't be too attenuated. It has to be in the moment. It has to be in the heat of the moment. That's what provocation is intended to be in every jurisdiction in the United States. So there's a lot of confusion about that. So let's get into the facts before the shooting, right? So we have this kid, he goes to Kenosha. This is a great point to take a pause here and talk about some things that are completely irrelevant to the question of whether or not Kyle Rittenhouse acted in self-defense. The fact that he traveled to a city that he didn't live in, irrelevant. That has nothing to do with what he believed at the time that he pulled the trigger.
Or that he was crossing state lines.
Or that he was crossing state lines.
Yeah, this comes up as an important fact sometimes in federal criminal cases, right? Because in federal criminal cases, you need to have jurisdiction, which means the federal court has to have the power to hear the case? How does the federal court have power to hear a criminal case? They basically almost always connect it to something called the Interstate Commerce Clause in Article 1, Section 8 of the United States Constitution, which frankly is another subject for another discussion. But crossing state lines would certainly be enough to confer federal jurisdiction. But this isn't a federal case. And so crossing state lines is basically irrelevant to this case.
Completely. He shows up early before the riots are happening, and I believe he cleans up some graffiti and does some things like that. Once again, irrelevant. Totally irrelevant. All right, so getting to the facts of when things are starting, the riots are actually kind of starting, and he's hanging out with this group of other gentlemen who are wearing AR-15s as well. They are asked to help protect a car lot. That's what the evidence tends to show. Most of that is completely irrelevant as well. And so now we get to something that might actually be relevant when he encounters for the first time Mr. Rosenbaum.
Yeah, right. Whether he was getting paid to guard the car lot,
irrelevant.
Whether he was there to look at the car lot, whether he was there to poke fun at the protesters, we don't care. Any of that stuff doesn't matter, right? It's not relevant to the analysis.
So he encounters Mr. Rosenbaum. Let's talk about some irrelevant things that some media outlets are treating as relevant. Mr. Rosenbaum apparently had a pretty shady past. He spent a lot of time in prison. There's some. It appears that his record reflects that he had sex crimes on his record. He was charged with domestic violence for strangling his girlfriend a few months prior to this riot. All irrelevant to the question of, at the time Kyle Rittenhouse pulled the trigger, did he believe that he was in imminent risk of severe injury or death?
Yeah, and also to add to that list of irrelevancies, that Mr. Rosenbaum may have had some mental health issues that might mitigate some of his conduct. Maybe we feel bad for Rosenbaum, he should have been treated or this or that.
Irrelevant, right? Completely irrelevant.
Even if you have mental health issues, you don't get to present substantial and imminent threats to other people.
If he was the shadiest person with the longest criminal rap sheet or a Nobel Prize-winning laureate, irrelevant.
That's right. Unless Kyle Rittenhouse knows.
Well, this is where we're going to move into relevant things.
Yeah. Okay. Unless imagine for a moment that Rosenbaum had some past that was extremely violent and Rittenhouse knew about that. Okay, well, that might be relevant to Rittenhouse's mental state. But if Rittenhouse doesn't know anything about Rosenbaum, then the background of Rosenbaum is irrelevant, as you're saying.
Yes. So things that Rittenhouse was aware of. He had seen Rosenbaum acting sporadically. The evidence indicated that he was yelling profanities, that he was doing false steps, as they were described in court, where he kind of would do one of these, where it's kind of intended to provoke or show some sort of physical confrontational body language. And then he makes a statement that's heard by several people and directed towards Kyle Rittenhouse and at least one other of the men with the AR-15s, which is, if I catch you alone tonight, I will fucking kill you.
Yeah, that seems kind of a relevant statement to me. I'm joking, of course.
Statement.
Highly relevant statement, right? Assuming that Kyle Rittenhouse heard this statement, and I think the evidence is that he did hear the statement. He knew who made the statement. There was reasons for him to believe the statement, right? I mean, if this is uttered by a 4-year-old girl who's running down the street with a flower and saying, I'm going to kill you, okay, that's different, right? But this situation, I think, is very, very relevant. If somebody says, look, I'm going to kill you, we could take the person at their word. I think that's reasonable.
We also see Rosenbaum, the facts indicator, the evidence presented in court indicates he's acting sporadically and destroying things. He's lighting tipping over porta potties, lighting dumpster fires, swinging a chain around. Now, all this stuff is only relevant if Kyle was aware of it, right? So if he blew up a building next door, killing tens of people, and Kyle didn't see him blow up the building, it's irrelevant.
That's right. People don't understand this. There may be a lot of bad facts. Maybe this guy killed someone in his past. But if Kyle Rittenhouse doesn't know about it, it doesn't matter. We don't really care about the background of this guy. We treat everybody the same. right? Everybody gets treated the same. Now, if Kyle Rittenhouse was aware of the fact that this guy is setting fires and turning over porta potties and being violent and aggressive, okay, well, this is more reason for Kyle Rittenhouse to have reasonably believed that this guy's capable of violence. I'm watching him engage in violence right now. In fact, this isn't even disputed because, as I understand the evidence, the prosecutor even said if this guy had survived, I would have prosecuted him for the very serious crime of arson.
Mm-hmm.
So there's no question about that.
Yeah, very importantly, too, the evidence did indicate that Rittenhouse was in the proximity and witnessed at least some of this destructive, arguably violent behavior.
But chasing him down the street after threatening to kill him is hugely relevant and important information.
Let's talk about that. So the evidence indicates that eventually Kyle is separated from the other gentleman with the AR-15s and is walking down a street. There's some disagreement here and different ways to characterize what Rosenbaum does. The prosecutor makes it seem like Rosenbaum is just kind of hanging out there at one of the car lots. The defense tries to make it seem that Rosenbaum is kind of hiding behind a car with the intent to ambush Rittenhouse. And I don't think either side really convinced me either way, but it's really irrelevant because at that point, a chase begins. Okay, so here's the facts, and that everything, keep in mind, you can see the video. Keep in mind everything happens really fast, but here's the facts that the video and the drone footage apparently show. The chase begins. Kyle is running across the parking lot. Kyle turns around at some point and points or displays his AR-15, and Rosenbaum keeps running. Kyle then turns back around and keeps running away from Rosenbaum. Rosenbaum continues pursuit. A gunshot is fired by another protester behind Kyle Rittenhouse. So he is not looking towards the sound of the gunshot. He doesn't see it. Rosenbaum throws a plastic bag at Rittenhouse, which misses. And then finally, arguably boxed in, Kyle Rittenhouse turns around and, with Rosenbaum about 4 feet away from him, lunging towards him, fires 4 shots, killing Rosenbaum. Importantly, Rosenbaum has residue indicating his hand was on or touching the barrel of the gun at the time. So there's a whole lot to unpack there. Let's start with the concept of defensive display. You want to take this one, Marc?
Yeah. So, the part that gave me a little bit of pause here is that Rittenhouse turns around and points the firearm at this guy. So pointing a firearm is a threat of deadly physical force, and people get prosecuted for this all the time.
Aggravated assault.
Aggravated assault is what they get prosecuted for. This type of a crime in Arizona is mandatory prison. I'm sure it probably is in Wisconsin as well. 5 to 15 years is what you're looking at. This is a very, very common charge.
Notably, in both states, both in Wisconsin and in Arizona, simply pointing the firearm, you're charged with the same crime as if you had actually fired the firearm at that person.
Yeah, for sure. So this is a really serious act. I will mention that in Arizona, there's a statute called defensive display of a firearm. I think it's Title 13, 421, if people want to look it up. And basically what it says, it's sort of a little exception to the general rule, and it says, look, if somebody is threatening ordinary physical force, and you certainly have a threat of ordinary physical force, right? The guy's already threatened to kill him, he's chasing him, he's thrown a bag at him, so there's a threat of ordinary physical force. Well, then you're allowed to defensively display, not to shoot, not to discharge your firearm, but to defensively display in an effort to say, look, leave me alone. I think this is also important, and the reason that that's okay is because there's sort of this escalation of force, right? There's this continuum, and Kyle Rittenhouse, importantly, didn't turn and just discharge his firearm right there. He could have, and that probably would have been a problem right there. I think if he had discharged his firearm right there, this case may go in a different direction. But he didn't. He used a far lower level of threat of force. He pointed it very quickly. That didn't stop the guy. I think that's instructive as well. I think if pointing a firearm at somebody doesn't stop them, you have reason to think that they're certainly up to something no good. But you still have to believe at that moment that there's a threat, not just to somebody throwing a bag at you. Nobody gets to throw a bag at another person. That's an assault or a battery, depending on where you live. But it's ordinary physical force, an ordinary injury. It's not death or serious physical injury. So that by itself isn't going to be enough to let Rittenhouse pull the trigger, but you got more than that here.
Yeah, absolutely. There's another thing that we should talk about here, the fact that he's fleeing and what a duty to retreat is, because you heard the defense say this a lot during the trial. There is no duty to retreat in the state of Wisconsin, and similarly, we don't have a duty to retreat here in Arizona. But this is an important thing that weighs on the scale of reasonableness and imminency, right? Even though it doesn't say explicitly in the law that you have to run, running is the type of thing that you could do to have to put on that scale in the reasonableness analysis when it comes to imminency. Remember, he has to reasonably believe that it was necessary in that moment to pull the trigger. What are the types of things that if I was a defense attorney, I could point to show that my client had exhausted the other reasonable avenues? Well, he tried to flee. He was running away. He did everything he could until he didn't have any options anymore. And it takes the wind out of the prosecutor's sails also that your client is the aggressor. So these are all important concepts. So it's true. He did not have a duty to retreat. He chose to retreat. He should have tried to retreat first. Remember, this is also the dichotomy between what's the smart thing to do and what's the legally required thing to do.
Yeah, and even just to add on that, in the places that you have a duty to retreat, it's only if you can in safety, right? Only if you can safely retreat. Here, he certainly, I wouldn't say he could retreat in complete safety. People are running after him. People are firing guns. People are threatening to kill the guy. So it wouldn't have been unreasonable, in my opinion, for him to say, look, I'm not going to try to run away, turn my back to these guys. And indeed, after he turns his back, he hears a gunshot.
Yes, absolutely. He also doesn't know whether Rosenbaum was the person who fired the gun or whether the person who fired the gun was pursuing him. The evidence shows that the person who fired the gun, who's currently going to be prosecuted for it, and they were just waiting until after the results of this case before prosecuting the guy. But the evidence showed that he was friendly, at least associating that night with Rosenbaum. So Rittenhouse doesn't know if that shot was intended to shoot him or if the pursuit is active or who has the gun or anything like that. But here's an important part for me. This is an extremely important part that I've heard a lot of talk about in the media that I think we should take a moment. The evidence shows through testimony and through the video that Rosenbaum may have been going for the gun and trying to wrestle the gun or attempting to possibly take the gun away from Rittenhouse. I've seen some talking heads say, well, that's, he was unarmed at that point. That's just ordinary force. That's just him trying to take the gun. He wasn't trying to kill him. Kyle Rittenhouse brought a gun to a fist fight, these types of things. I can't believe that we have to make this point for people, but here you go. I'll be as clear as possible on this. Self-defense law does not require you to willingly relinquish your gun to your assailant and keep your fingers crossed and hope that they don't turn around and use the gun against you. This is what a lot of people are saying. Well, he could have just given up the gun. He could have just handed it over, or he could have, done something like that. Self-defense law does not require you to say, okay, fine, you win. Here's my gun. Please, I'll keep my fingers crossed that you don't hurt me with the gun.
Yeah, of course, general rule, right? You don't get to use deadly physical force to protect property. And so, of course, if you frame this issue as, well, this was just a simple theft of his firearm, and you don't get to use deadly physical force to stop that theft of the firearm. That's true, but in these circumstances, after the guy has already threatened to kill him, there's good reason to think that if this guy takes Kyle Rittenhouse's firearm away, that he might be a man of his word. And your point is well taken. You don't have to, even if somebody's trying to steal some of your property, you do have a right to resist that. You have a right to say, no, I'm not going to give it up. You don't get to use deadly force to protect it. But in the case where you have a reasonable belief, an actual belief, subjective belief, and a reasonable one that the reasonable person in the community would say, yeah, I agree with that type of a belief, that this guy might take the weapon and then shoot me with it, absolutely. You don't have to allow that. In fact, you'd be a fool to allow somebody to take your firearm. At that point, it seems to me you don't have to gamble on your life. You definitely are justified in using deadly physical force at this point, given all the facts. That's exactly what the jury found here unanimously.
Yeah, and another important point here that kind of links back to something we were talking about earlier. Even if Rittenhouse is mistaken that he wants to take his gun, even if Rittenhouse is mistaken that the gunshot, for example, was intended for him, but it was just up into the air instead, even if he was mistaken about all these things, if a reasonable person in his shoes would have believed it at the moment that he pulled the trigger, then it's going to be justified under self-defense. So what did he know when he pulled the trigger? He knew that he was being pursued. He knew that a defensive display didn't work. He heard a gunshot behind him, not knowing the origin or the gunshot or whether it was intended for him, and he knew that the person pursuing him and reaching for his gun had burned things and acted violently and sporadically and had told him that he was planning to kill him.
Right. And I think it's important just to keep in mind this is in the context of a criminal trial. And so, we, as you pointed out at the beginning, this is supposed to be skewed in favor of a not guilty here. And indeed, the rules as we've laid them out are. But that doesn't mean he can't be sued civilly, right? I mean, still, although we want to be very, very careful when we convict someone on a criminal charge. This guy's looking at the rest of his life. You're talking a really, really serious consequence. He could still be sued. Like the O.J. case, right? In the O.J. case, he was acquitted on the criminal trial and then was sued successfully, civilly. That could happen here. And so there are different rules that apply in the civil realm. This is really just dealing with the question of the value judgment that we make in the United States of America, which is before we put someone in a cage, we want a lot of protections, and we would rather 10 people who are actually guilty go free than one person who's actually innocent gets mistakenly convicted. That's the reason for this type of a protection and high standard.
So I think that of all the charges, to me, this one was the closest call.
And it wasn't that close, frankly.
It wasn't that close. And keep in mind, just as you just pointed out, maybe you think that there's a 70% chance that Rittenhouse did not act in perfect self-defense here. Not guilty.
Yeah.
Skewed against. So
and sue him. He might be liable.
He might be liable.
Right.
If he's 70% that the chance that he was negligent, then Rosenbaum's obviously his estate can come after him in a civil court and go for lots and lots of money damages, everything like that, but not in the criminal context. So Rosenbaum then falls down, and Kyle gets on the phone, calls somebody, and basically says, "I shot somebody. I don't know what to do. I need to go turn myself in."
We should point out too that, and I don't know about this in Wisconsin, but the law may prohibit a civil case in Wisconsin because the jury found him to be not guilty. That's probably the right rule, in my point, because self-defense is not just an ordinary defense. It's not just saying, hey, you failed to prove the case. It's a complete justification. It's saying what I did
was legally
justified. And so there shouldn't be any liability in that type of a circumstance. So that's not a question we can fully run down today. Just want to throw that in there.
Yeah, good point. So then at that point, speaking of running, he starts running, right? There's a video, which we'll put up right now, where he's running down the street, and a bunch of people are chasing him. They catch up with him eventually. You see the first contact is somebody hits Kyle in the back of the head. The defense argued that the person had an object in their hand, a rock or something like that is what they went with, but he gets struck in the back of the head, either with a closed fist or with an object being held with a fist. And then Kyle staggers and falls on the ground. Several people run up. One person they called Jump Kick Man comes and kicks him in the face, allegedly. I think the prosecutor disputes that, but you see his body spin in the video, and it seems to indicate that there was contact made between the foot and the face. That alone can kill you right there.
No question. That guy got away with a serious crime right there. I think there's a good question if Rittenhouse had seen that kick coming, could he shoot and kill Jump Kick Man? And I think probably yes, right? Because a kick to the face like that when you're down on the ground, or really even if you're standing up, that's definitely serious physical injury right there. So a Jump Kick Man gets away pretty free and clear here in this one.
Next up is Huber. Huber is the guy with the skateboard. Let's talk about things that are irrelevant. Huber's been to prison twice. He had apparently kicked his sister or something like that. Irrelevant.
Yep.
All of that is completely irrelevant. Rittenhouse didn't know anything about those things. So, once again, folks on the right trying to slander the victims as these horrible, horrible people. And I use victims in a legal sense, right? There was some debate over what they would be called during a trial, which we should talk about that rule. Let's talk about it at kind of. There's a few auxiliary issues I want to spend a little time on, but getting back to the facts. Hubert's the skateboarder. The video shows him hitting Kyle twice with the skateboard in the back of the neck. This, to me, is clearly threatening deadly physical force and using potentially deadly physical force. If the truck was to make contact, the truck of the skateboard, the metal part, was to make contact with his head, that's lights out.
Yeah, people who are saying, come on, this thing's just a skateboard, this isn't a firearm, these people are far off base here. Remember, it doesn't have to actually cause death, but it's something that could cause death and certainly could cause serious physical injury. And the law doesn't say you got to put up with that. You can use deadly physical force to protect yourself against anything somebody else is doing that could imminently result in death or serious physical injury. Certainly reasonable to believe that Kyle Rittenhouse thought, well, he was, after he had just been kicked by Jump Kick Man, been threatened to be killed, and then now somebody is coming up and whacking him in the back of the head with a skateboard, that he actually was at a risk of a serious physical injury. And I think any reasonable, unbiased person in that circumstance, again, without regard to the color of skin or the motives or any of these other things, if somebody is hitting somebody else in the back of the head with a skateboard, that's definitely something that can cause serious physical injury. This one's an easy one for me.
This is an easy good shoe. Next up is Grosskreutz. Grosskreutz, let me tell you some things about Grosskreutz that are completely irrelevant. Apparently he's a prohibited possessor because he's a convicted felon and wasn't allowed to have the gun with him that night. Irrelevant. Totally irrelevant. Rittenhouse knew nothing about that. It doesn't go into what did Rittenhouse believe at the time that he pulled the trigger.
Did any of that come into evidence?
No, none of it did, but it's major talking points.
None of it should.
Yeah.
None of it should.
Major talking points seems to be the character of Rittenhouse and the character of the people he shot, and all these things are swirling around this trial. But rightly, none of that came into evidence because it is completely irrelevant. He also belongs to a group that has been labeled as kind of Antifa supporters and kind of troublemakers. Once again, irrelevant. It was not known by Rittenhouse at the time. But what is relevant is that Grosskreutz had a gun. He had a pistol, and the big kind of bombshell moment came out in trial that Grosskreutz admitted on cross-examination that it wasn't until after he pointed the gun at Rittenhouse's face that Rittenhouse then fired and wounded him.
This is unbelievable to me. This is unbelievable. Unless the prosecutor was so incompetent that he didn't know this was going to be the testimony. If you are the prosecutor and you know that your witness is going to say, I was advancing against this guy, pointing a gun at him at the time he shot me, shame on you for bringing that charge. Shame on you for bringing that charge.
Yeah, this is obvious good shoot.
Yeah, this is crazy. This to even charge this. Actually, either of these, or maybe even any of these, it doesn't seem to me, and I think it's pretty quick the way this case got charged, right? This isn't the normal. We should say something about that, too. Normally, these kinds of cases, the shooting happens. Oftentimes, the person who is accused is out of custody, especially if they don't have priors and they have good ties to the community. Then there's a long investigation where experts come in and the scene is blocked off and things are measured and we know where this was and that was and the next thing was. And it can take several months or a year.
Or a year.
Not uncommon for a case like this to sit for 1 year so that we can know exactly what the facts are. This thing was charged, I think, within a few days.
Immediately. Yeah.
Immediately. No investigation whatsoever. At some point, the prosecutor has got to learn that his star witness is going to give the clearest case you could ever possibly hope for as a defense attorney. What would you hope for in a self-defense case? Well, that the state's star witness comes out and says, yep, I was pointing a firearm and advancing against the guy at the time he shot me. we could only hope for a prosecution like this, right?
Yeah, you and me, when that came out, I remember we talked, we're like, why don't we get prosecutors this stupid in our gun cases?
And speaking of, can we go off on a tangent about this prosecutor for a second?
Why not? I got some things to say.
Did this guy... tell me this isn't true, Andy. Did this guy pick up an AR-15, not look to check and make sure after what had just happened on the set of Rust, just shortly after this, not even check personally himself to make sure it is unloaded, point it at jurors or other people in the courtroom, which is just unheard of, and then put your finger on the damn trigger at the time you're doing this? Did that actually happen in this case? That
happened, and it went viral all over the place. So, yeah.
I don't even know what to say about this. I mean, I just don't even know what to say about this. It's almost like if someone in the courtroom had shot this prosecutor at the time he's doing it, they might have had a good case for defense of others or something. This is just gross negligence.
Yeah, so let's talk about some other things. Once again, these things are less relevant than people think about, which is the judge and the prosecutor butting heads over rulings and different things that the prosecutor did. So first of all, it's important to note, because there's a lot of misinformation about this. On all of these viral clips that have the judge kind of going off on the prosecutor, the jury did not see any of that.
That's right.
All of that was done outside of the presence of the jury. So anybody saying, well, if the judge acts like this and shows disfavor to the prosecutor in front of the jurors, that's a huge problem and it biases the trial. The jury didn't see any of that. The judge, I thought, handled that pretty well. Whenever there was an issue, he asked them to go out into the next room, and then he handled it. So let's talk about the big one that happened with this prosecutor. There are two main things that really the judge raked him over the coals for, and we'll show a quick clip of that video.
And by the way, these discussions that are outside the presence of the jury happen on multiple occasions in every trial.
All the time.
I have never tried a case in my almost 3 decades of trying cases that we didn't have on multiple occasions what we call a sidebar, or let the jury go. You know, sidebar is, hey, we're going to sort of whisper up there so the jury can't hear, or get the jury out of the courtroom, or in the last trial we walked out of the courtroom. The defense attorney, the prosecutor, and the judge all exited the courtroom to discuss something, then we all came back. But things are said, discussions are had all the time out of the presence of the jury, so entirely appropriate.
Okay, first and foremost, let's talk about something that every law student learns, like your first semester of law school, when you're learning about your right to not incriminate yourself. You learn about the Fifth Amendment. You learn it in substantive criminal law. You learn it in criminal procedure. You are not allowed to comment on the defendant's post-arrest silence. So in other words, if a defendant says, I'm invoking my right to remain silent. I want an attorney. I don't want to give a statement. I don't want to talk to the police. That's a very, I want to use the term sacred. I want to say that's an important right. It's so important.
Criminal Law 101.
This is easy, basic stuff. That's one of the first things they'll teach you in your criminal law class. And the reason it's so important is we don't want to penalize defendants for invoking their right to remain silent.
Imagine if we didn't have this rule, right? And the rule was deleted, and so a defendant is arrested, told that he has a right to remain silent. That's what is allowed. It's one of your constitutional protections. You do not have to make a statement. You don't have to incriminate yourself. And he says, look, I'm not going to make a statement. And then a prosecutor comes out, and maybe even in closing argument says, well, if the guy was actually innocent, why didn't he tell the police he was innocent? The guy instead chose not to make a statement. This is obvious evidence of his guilt. And so we don't allow the jury to make that kind of an inference. And because they're not allowed to infer that the person is guilty simply because they remained silent, the rule is and has been for many, many decades, the prosecutor does not get to comment at all about the fact. We just ignore it, right? So if the defendant says, look, I want my lawyer here, I have no statement to make, we ignore that, we go right through it, and every prosecutor knows this.
Yeah, absolutely. And apparently this prosecutor forgot it because he opened up his cross-examination by saying, this is the first time that you're actually given a story, isn't it? You know, the implication being that he was making it up on the spot because he hadn't given a statement. That immediately caught an objection objection, the judge tried to correct the course there. The other thing that the prosecutor stepped in that day is he violated a pre-trial order from the judge. So let's talk about this real quick. We lawyers file lots of motions before it ever goes to trial. The way trials are shown on TV is very sexy. Things will just happen all of a sudden that nobody expected, and there's gas in the courtroom, and in real life, that doesn't really happen very often. The reason it doesn't happen often is because we file lots of motions ahead of time to figure out exactly what evidence is going to come in and exactly what evidence is not going to come in. We call this a pre-trial motion. So in this case, there was a statement made by Rittenhouse. The statement was made allegedly about 2 weeks, I believe, prior to the shooting. It was something to the extent that he had witnessed shoplifters or something like that from a store, and had spoken to somebody and said, if I had my AR-15, I would shoot them and stop them from shoplifting, something like that. This is rightly excluded. It is irrelevant to the question of, at the time that he pulled the trigger, did Kyle Rittenhouse believe that he was in imminent threat of death or serious physical injury? The prosecutor, of course, wanted to introduce this because it tends to make him look like a bad guy, but the judge correctly excluded this as propensity evidence. You want to say something about propensity?
Let's talk about this. And I'm not 100% convinced I agree with this rule.
I agree with that your skepticism of it, but why don't you explain?
Yeah, here's the concept here. Character evidence is just evidence that tends to show the person maybe is a bad person. And the danger of admitting this here, at least as alleged by the people who like the character evidence rule, is we don't want, and again, I think reasonable minds can disagree here, so I don't want to put too clear of a position out there, but the idea is that if we let jurors hear about all of the bad things you've done in your life, then the jury is going to say, look, this is a bad guy. We see what we're dealing with here. We're going to just find him not guilty, not based on the evidence in the case. Or we'll
find him guilty, rather.
I'm sorry, we're going to find him guilty, not based on the evidence in the case, but on the fact that this guy's a bad guy. And so because of the danger that a jury is going to convict, the general rule is this type of evidence, we call it character evidence, is excluded. Now, there are exceptions, and like a lot of rules in the law, that sometimes the exceptions kind of swallow up. And so I'm sure what the state argued is, look, we're not bringing in this evidence just to show he's a bad guy. We're bringing it in because it goes to show his intent at the time of the crime.
Right.
He likes to shoot people. And okay, so maybe this
specifically, I think it was like this tends to show that he is willing to use force to protect property.
Okay, and so that's the argument. But this gets hashed through long before the trial starts, and then the judge will read case law, which are similar situations in the Court of Appeal and Supreme Court there in Wisconsin, said, here's how we feel about it. And then the judge makes a ruling. It's called a pretrial ruling, and says, look, unless something changes, now something can change, right? The defense can, as we like to say, open the door. Mm-hmm. They might put something out there that makes this more relevant, or like now, Kyle, you've never said anything like ever wanted to shoot anybody, right? That's right. I've never said any such thing. Okay, something like that is going to allow the judge to reconsider and bring in that kind of an evidence. But if the door's not opened, the judge has decided this doesn't come in. So what happens very commonly, and happened in this case, is the judge says, this is my ruling, but I'm going to remain open-minded. If something changes in the case, bring it to my attention, and maybe I'll change my ruling. And so lawyers are supposed to be professionals. Most of them are. The vast majority of them, in my opinion, the ones I've dealt with, have been very professional and would say, excuse me, Judge, can we have a sidebar? That's how this goes. Andy and you and I have had this situation.
We've had this many times.
Excuse me, Judge, could we approach? Ever wonder what happens? Well, these are the kind of thing that happens. Judge says, sure, approach. And we say, Judge, did you hear what he said? He's opened the door. We should get to bring this evidence in. That's what the prosecutor should have done. But instead, what did he do, Andy?
Well, he just went ahead and asked the question that was explicitly banned by the pretrial order. And so that's why it immediately drew an objection. You got that kind of fiery interaction between them outside of the presence of the jury. But the judge smacked him by basically saying, look, did you not read my pretrial order? Furthermore, I said just a couple of hours ago at the beginning of evidence today that I've seen nothing so far to make me change my ruling. And as Marc just pointed out, we've been in this situation many, many times. I remember a very dramatic one that actually happened in a federal case that we did where the prosecutor opened the door to something that was specifically barred by a pretrial motion. We lost the fight pretrial to get that piece of evidence in, but the prosecutor opened the door. So opening the door, basically, when you ask them something that you have some evidence that could prove the opposite of what's going on, the fairness, the idea of fundamental fairness is that you need to be able to rebut what they just said.
Yeah, you love it when that happens, right? When it happened in our case, now we get to bring the evidence, a misstep by the prosecutor. But you have to do that, right? You can't just go piling through and
you don't just get to go up and ask the question. That's the point here, is that in that moment when that happens, you ask politely to go and talk to the judge. The judge will grant it. You'll walk up. You'll make an argument that they just stepped in it and opened the door. You don't get to say, I'm going to tell the judge that you're going to ask the question in violation of the pretrial order. You make an argument that they stepped in it, and then you allow the judge to make a rule. This is basic trial etiquette.
Any judge would have been upset at this point.
No question.
To try to say that this is some kind of evidence that the judge did something wrong or was upset with the prosecutor for unjustified reasons is outrageous. Because, this is, I think, part of the reason why the judge took this thing under advisement, this mistrial. And there were some other missteps as well, which is the evidence disclosure. I don't know if we know that.
Right, with the grainy image and everything.
Yeah.
It wasn't the same thing that they were disclosed.
Yeah, and so the judge very wisely, I think, took this mistrial under advisement. Why did the judge do this? This is a tactical thing, right? Because if the judge grants the mistrial, well, this can be appealed. And the appellate court might see it differently. You might be starting a whole new trial from scratch. And what if, even with this mistake, the jury comes back with a not guilty? Then you don't have to make that decision. So a lot of savvy trial judges will do exactly what this judge did and say, look, I'm going to take it under advisement. I'm going to hold my ruling until even after the jury comes back, and then I'll make a decision. He may have granted a mistrial had this come back with a guilty.
This is the type of appellate issue that defense attorneys drool over. So let's explain that. Had Kyle Rittenhouse gotten convicted, he then starts the appellate process. This is where you appeal to a higher court to say something went wrong. Something went wrong during my trial such that I was deprived of my right to a fair trial. And I want another one. I want a redo without the error. And so he would have an appellate lawyer, and the appellate lawyer would file and would point out all the legal issues. Well, these are exactly the type of issues as when we're doing appeals that we salivate over. How could you possibly have gotten a fair trial when the prosecutor's asking you about a fundamental right, your Fifth Amendment right to remain silent, and violating court orders, and these are just the type of things that we would have argued get him a new trial.
And this other issue of disclosing a lower quality video might be a serious issue.
I think so too.
You look at those videos and it's difficult to see. It's difficult to make an argument. And boy, if there was a better copy out there that would have allowed the defense to make a better argument in defense. And again,
just what the facts are in this is that my understanding is that what was disclosed to the defense. So the prosecutor is required to disclose all of its evidence to the defense so they can see ahead of time what's going to be presented against their client and prepare accordingly, because that's their right, fundamental fairness right.
We don't want trials by ambush.
We don't want ambush. We don't want sandbagging, as we call it, where they will just bring something that the other side has never seen before without giving them proper rights to look at the evidence. And maybe they would have wanted to get their own expert to analyze it. Right. So what was given to them was different than what was actually shown at the trial.
Now this might have been an unintentional thing, right? This could have been, hey, the computer compressed the file or something. We didn't really know. But still, it's a real problem, right? Because if you're the judge, you got to say, wow, is this a fair trial? Your job is to not require a perfectly tried case. Nobody's entitled to a perfect trial. But was it imperfect enough that we can say it wasn't a fair trial anymore? And this might be that kind of an issue, which is why I think it makes a lot of sense to sort of withhold this type of a ruling, see what the jury comes back with, because you can always give them a second bite at the apple later, especially if you think the Court of Appeals is going to say, say, we can't say this was a fair trial because the defense had a lower quality copy of a very important video.
Yeah, it was very strange. Some media outlets were commenting that it was odd that the judge didn't rule on the mistrial motion within the first 24 hours that he received it, before even the state had a chance to respond to the motion. So this is just, it's ridiculous. This is a common thing that a judge will take his time, his or her time with the mistrial motion.
The judge's job is to make sure that that he's presiding over a fair trial, which is why the thing that happened with MSNBC as well. We don't know exactly what happened. It seems like maybe someone from maybe a contractor to MSNBC was following around the jurors. And, these go into the factors of, do you sequester the jury? Do you hold them up at a hotel somewhere? This is a high transaction cost. You're asking people to be pulled out of their lives. So the judge didn't make that decision. But because of that, now you got the press chasing around jurors. Is this intimidating jurors? And the judge has to take some swift action in what might otherwise look like a First Amendment problem, excluding the press. The judge is like, look, we're going to have a fair trial here. I am not going to let MSNBC into the courtroom. And I think the judge, was very clear, was frustrated by all the ridiculous and false, maybe even fraudulent coverage by some of the news stations. And there might be erroneous coverage on both sides here, so I think I might be calling out both sides, but all of the irrelevancies and things that don't go in, one we hadn't mentioned, that Kyle Rittenhouse was photographed with some of the Proud Boys. What the Proud Boys stand for, whether he's a member of the Proud Boys, whether he's a white supremacist or not, is all irrelevant in this case.
Yep.
So, if people are talking about that might be interesting stuff to talk about, but not relevant to the question of self-defense.
Yeah, a couple other auxiliary issues that we don't need to spend a lot of time on because they're relevant to the legal analysis, but a lot of talk about in the press is that, the concept here and how the prosecutor definitely wanted to frame Rittenhouse is as a vigilante. He basically went out there to do vigilante justice and everything like that. There is a little bit of irony that I've noticed that I don't think folks who are making that argument are picking up on when it comes to at least the folks who were chasing Kyle Rittenhouse down the street after the Rosenbaum shooting. Because the idea was, and I see there's arguments that the Huber, for example, the guy with the skateboard, is a hero in his own right because he went to go chase after what he perceived as an active shooter and attempted to take on a guy with a gun with a skateboard. So therefore he's heroic. I don't think folks who are making that argument understand the irony that they're criticizing Kyle Rittenhouse for being a vigilante, and that is exactly what Huber and Grosskreutz and Jump Kick Man and all of them were doing. They witnessed a crime and decided, we're going to be heroes and stop the active shooter, rather than the idea with, to avoid being a vigilante is you either report it to the authorities or you ask the cops to help you out or something like that. When you take the law into your own hands, I want to be clear here. I'm not trying to argue at all that people shouldn't rise to occasions when there are reasons to do so. I love stories that I hear about people neutralizing active shooters and active threats and everything like that. But whenever part of why it's heroic to be a vigilante, which is exactly what those three people I mentioned did, part of being heroic is you run the risk that the person that you are trying to stop is actually legally justified in shooting, number one, and the reason you're pursuing them, and might have a valid claim to self-defense against you for your wrongful perception that they didn't have a good shoot.
Yeah, a couple, some important points here. First off, you have not only a right to defend yourself, but you have a legal right to defend a third party. So what this is saying is, look, you do have a right, in essence, that's codified in the law, to be a vigilante. You better be right, because as you point out, you might be wrong. Now, Arizona has a section called Mistake of Fact, 13204, I think it is. That's very interesting because, and I agree with this section, by the way, it basically says, look, if you were mistaken about the facts, you thought you were acting in defense of yourself or defense of a third party, and it turned out you were flat wrong, but if the facts had been the way you thought they were, you would have been justified. This is a complete defense in Arizona.
And you hear that reasonable term come up here, too. It's a reasonable mistake of fact. You're not allowed to just believe whatever you want. It has to be based in fact.
That's right. If you made a mistake and it turns out the person you say somebody jumps out of the bushes and they look like a troublemaker, whatever that looks like, and they tackle some female who's jogging down the street, and you defend, you'd say, hey, I'm going to take my gun, or I'm going to go beat up the person who jumped out of the bushes. And as it turns out, the person who jumped out of the bushes was an undercover police officer trying to make an arrest, serve an arrest warrant or something on this female who they were looking for a long time. And this is a big oops, right? Well, if it's a state case under Arizona law, you could make the argument, look, I was reasonably mistaken about the facts, and if the facts were the way I thought they were, then I would have been justified. This gets you out of criminal liability. You still get sued.
You can sue them, yeah.
In the civil case, you still get sued, as you should. But do we want to put people in prison who have the right things in their head? That's what they have, a good mens rea, as we like to say. And the value judgment here is no. Criminal cases are generally reserved for situations when the actor has some bad ideas, bad motives in their head. They're up to something bad. Not that they're up to something good and they're mistaken. And so I think this is a minority position across the country. Generally speaking, if you defend the rights of a third party, you stand in their shoes. And if they didn't have a right to defend themselves, you are, as they say, SOL. Out of luck.
Yep, that's right. Another auxiliary issue that we touched on a little bit earlier, but let's get into. There are allegations, there are lots of allegations that the judge was biased in favor of the defense, and a lot of those rested on some of his pretrial rulings. One of which that made headlines is that he said that the people who were shot by Rittenhouse are not allowed to be called victims in front of the jury. And at the same time ruled that the people who were shot by Rittenhouse were allowed to be called rioters or looters if and only if the evidence showed that they were rioting or looting. I saw a bunch of media outlets say this was outrageous. This clearly showed bias. You have any thoughts about calling the people who were shot by Rittenhouse victims in front of the trial? Did the judge get this one right?
Judge totally got this one right. In fact, this is an argument I've brought on many occasions. I mean, think about calling, especially in a self-defense case, right? Having everybody call the people who you're trying to argue are the aggressors, calling them victims for the jury. This is making a judgment that is basically telling the jury they're victims. So, of course, if they're victims, then the self-defense is unjustified. You're making that conclusion ahead of time. It's fine to call them alleged victims, right? Because we make it very clear the defendant is charged with the crime. They're allegations. They've not been proven. We tell every juror this. So I think there's nothing wrong with that ruling. I think it's a perfectly fine ruling. What the judge is doing with the rioters and saying, look, if there's evidence that they're rioting, okay, fine. If there's not evidence that they're rioting, because the judge is making an important point here too. And it's the same point we make in all these situations. Not everybody who is present in attendance on any of these occasions, whether it was January 6th or any of these other protests where people are burning things and looting things, to lump everybody into the same category, which is often done by the left and the right, different categories, but the same categories, just flat wrong. We have to make an individualized judgment on each person. And so if the judge is just saying, look, if the facts are there and they can be supported, then okay, I'm going to let them called rioters. But just because they were there isn't sufficient. That seems reasonable to me, too.
That's totally reasonable ruling. And just for the non-lawyers out there, this term victims, it's obviously a charged term. That's why the judge ruled the way he did. But it's also a legal term of art. So whenever we have, basically in our cases, whenever we work cases, mostly for shorthand purposes, the state will list people as victims of the crime. So we just we call them the victims, maybe in pleadings and rulings and during argument and things like that, but really they're alleged victims. And that's what the judge was trying to get to here, basically.
Yeah, I mean, to be fair, and there's really two purposes, right? One, we call them sort of pretrial, we call them victims because there's certain rights that attach to that. Like,
yes.
For example, in Arizona, You don't get to do a pretrial interview of somebody in that status as a victim. It also means that if someone's in that status of a victim, you could have a domestic violence enhancement on the case. But in terms of at trial, referring them to the victim, I mean, it's almost like referring to the defendant as the guilty person. Yeah, this is the guilty person up here on the stand. And, look, we're trying to get to a fair trial, right? I mean, for everybody who's so upset about this, take all the other facts out and think about, put your citizen hat on for a moment. How should we conduct jury trials in criminal cases?
Go a little further than that. Put your defendant hat on. Pretend it was your trial, and you're trying to argue that what you did was lawful and right, and the people who are accusing you are just automatically called the victims in front of the people you're in front of the jury. You wouldn't want that.
No.
You wouldn't want that in your own trial.
No. And I understand everybody's got political motives and people want to see this, that, and the next thing. But look, this is a criminal trial. And I think the judge, because, I've been through high-profile cases. When I defended Elizabeth Johnson in the Baby Gabriel case, we had an army of press outside the courtroom. There were cameras in the courtroom the whole trial. They're different. There's definitely a different type of a situation when you're trying a high-profile case. And just like Sherry Stevens, one of the judge who presided over the Jodi Arias case, I was one of the main commenters on that case. She was under fire during that case because of the press, and things can get out of. In fact, she was criticized. And Sherry Stevens, generally pretty good judge. I've been in front of her on many cases, but she was criticized because of her failure to deal with some of the crazy press coverage, and some people referred to that trial as a circus. This judge, you got to be kind of tough on a case like this, and that's why he took that very swift and very serious action of banning MSNBC from the courtroom. Whether they're on the right or the left doesn't matter. I hope that if had been Fox News that was chasing down the jurors, that the judge's ruling would have been exactly the same. It should have been exactly the same. So, look, nobody gets a perfect trial. But this is how we resolve these types of issues in a civilized society. You get a fair trial. It's not perfect, but for the most part, it seems to me the judge applied the rules correctly, not just the self-defense statutes, but also the rules of evidence, whether you agree or disagree. There are value judgments all in there, and like I said earlier, there are some I disagree with, but I can't say that this was a trial that was just unbiased or was biased or unfair or something like that. And look, we need to accept what the jury said. I mean, double jeopardy applies. We don't try people twice. This move to try to now bring this into the federal court and try to bring federal charges against Rittenhouse is just outrageous. I know that the law, the black letter law, and I think this is wrong, by the way, on double jeopardy says, look, yes, you can be tried twice, once in the state court and once in the federal court, because we have this legal fiction that the state is a separate sovereign from the federal government. This is a complete fiction.
Yep.
The Supremacy Clause of the United States Constitution makes it very clear that federal law is the supreme law of the land. And so while a technical legal reason that I think is wrong would permit the federal government to bring criminal charges against Rittenhouse in the federal court, this would be, in my opinion, outrageous. It's almost never done. I can't think of one client I've had, and I do state and federal cases over my almost 30 years, who has been tried in the state court and then was again tried in the federal court.
For the same crime.
For the same crime. I certainly hope that doesn't happen. But it just goes to show you the sign of the times. If you don't like the results you got in the state court, let's drag them into federal court. That's outrageous, and every American should be upset about that, regardless of how you feel about the verdict here.
Agreed. And I thought it was very notable, too, that the judge made so much commentary kind of in between, obviously outside of the presence of the jury, but made so much commentary about incorrect rulings and incorrect analysis, I should say, that he was seeing coming from the press. And the reason this is kind of controversial, too. He was naming specific networks and reporters and investigators and lawyers who were commenting on it, and took every chance that he could, it seemed, to call those folks out and say, here's why I ruled the way that I did. Here's what the case law says. And the reason he noted for doing that is because he wanted to ensure that the public had confidence in the verdict of the trial. This is something that I disagree. I don't know if I disagree with folks on the right on this. I think I disagree with them when a lot of them are saying this is so outrageous it should have never been brought to trial. I'm happy that it did. I'm happy that all the facts came out. I'm happy that I feel bad for everybody who was involved in the case, but I'm happy that the facts came out, because you can imagine if this case wasn't tried and all that was out there, hanging out there, was the narrative in the media, which turned out to be completely wrong in many, many aspects, and no evidence whatsoever presented in court to challenge it. They would have had a field day with it, we wouldn't have had a proper acquittal. So
yeah, but if you take the air out of this case, if you take all the publicity out of this case, this isn't a case that ever, I think, is even charged.
Right, we wouldn't normally see something like this unless it was all high profile and politically charged and everything like it would. The prosecutor probably would have taken a pass on a case like this.
No question. There certainly would have been a very good plea on this case that would have been too good for Kyle Rittenhouse to refuse. Here's a misdemeanor plea or something like that, or a diversion even, or get some more gun safety classes. Regarding the judge commenting on the press and calling people out, look, there are different interests in a criminal trial, right? Obviously, the main interest is making sure that the defendant gets a fair trial. There's a societal interest in making sure that people who commit crimes are prosecuted and dealt with properly. There's punishment, deterrence, rehabilitation. But what the judge called out, this issue of we want to make sure the public has confidence in what we're doing over here in the justice system. I got to say, for me, it kind of warms my heart that the judge cared about that. I think the justice system does get some unfair criticism. I want to be clear here. Lots could be improved in the justice system. In fact, until we get rid of victimless crimes, we're always going to have a screwed up justice system. So we need to do that first and foremost. And lots can be improved, but there are a lot of unfair allegations that are lodged against our criminal justice system. And I think the judge was very sensitive to that and was sensitive to the notion that I don't want to leave people with the impression that this is a kangaroo court going on over here. There are rules of evidence. Here are the cases I'm citing, the statutes I'm citing. You can read them for yourself and see what's going on. I kind of like that the judge, in a high-profile case like this, in a situation where the press is horrendously distorting what happened. I can tell you, I've done a lot of high-profile cases. For the most part, the coverage is almost always wrong. Sometimes I read it in the paper, and they're commenting on what happened that day in trial, and I'm saying to myself, were they watching the same case? But in this case and in this environment, I think that was by a multiple of 10. And so I like the fact that the judge took a little bit of time to defend kind of what we're all doing in the justice system. The good people who are working in the criminal justice system, and I'm talking about judges, defense lawyers, prosecutors, because we've run up against some very, very good professional prosecutors who raise issues that benefit the defense because they want to preside over a fair proceeding.
That's right.
There are prosecutors out there, many of them.
No, let's take a moment here. Prosecutors have a different obligation than defense attorneys.
Good point. Yeah.
Prosecutors have an obligation to do justice, not to win, okay? Defense attorneys, we have one goal, which is what's in our client's best interest. That's all we care about, is what's in our client's best interest.
And our ethical obligations.
And those ethical obligations to do that to the highest ability as possible. The prosecutor, on the other hand, has maybe a little bit of extra responsibility that's required by the state bar that they practice in. They are not supposed to just be after wins. They're not supposed to just be in it to win it. They're supposed to do justice. They're supposed to do everything that they can to make sure that the truth prevails. This is why, if you saw some of the commentary from the defense attorney after the trial, in which he was asked, what did the prosecutor do that you thought that was inappropriate? He mentioned that the prosecutor put two witnesses on the stand that he knew were going to lie. The police, it was the two brothers, I believe, who owned the car lot, who had asked them to protect the car lot. The police, apparently, in the police reports, said, we knew that these two guys were lying. And so the defense attorney alleges, and I don't know whether this is true or not, but this is why the defense attorney was upset, that the prosecutor, knowing full well that his agents, that the police, thought that this guy was a liar, chose to put the two brothers on the stand to testify to those lies under oath. The prosecutor prosecutor isn't supposed to just be doing it to win. The prosecutor's supposed to be pursuing the truth and justice.
Yeah, they're supposed to be the guardians of a fair trial. Isn't that what we would want them to have for an obligation? They have obligations to turn over any evidence that is exculpatory, which tends to show that the defendant is not guilty from whatever source they learn it from. They have duties to investigate, to ask the cops, hey, do you have any information that tends to show the defendant is not guilty? And then to turn that over. They can't play hide the ball. This thing is not a sporting event. It's a serious event. And if the prosecutor did put people up that he knew were going to lie under oath, look, that's the kind of thing that gets you called in front of the state bar and there's an ethics investigation, and it ought to be. I don't know if he did that or didn't do that, to be fair. But if there's even an argument about that, that's something I hope the state bar looks into.
One other thing I really don't like about this prosecutor, once again, totally irrelevant.
Oh, yes, I know what you're going to say.
As a Star Wars fan, my understanding is he walked in on jury selection day or one of the very early days of the trial with the Rebel Alliance pin on his tie. Well, as a Star Wars fan, if you're not familiar with Star Wars, the Rebel Alliance is a ragtag group of kind of rebels who are fighting this giant empire. It's called the Empire, and they're this big evil, they're basically the government of the galaxy in Star Wars. For the prosecutor, the man of the king, the guy who works for the state, literally couldn't be more of an imperial officer who has all of the cops on his side, so the stormtroopers, all of the unlimited resources at his disposal. Couldn't be more of the epitome of the Empire. To walk into court with a Rebel Alliance pen was, even with the media completely on his side, everybody on his side, to walk in saying, I'm part of the Rebel Alliance was...
This is the thing that pisses you off more than anything in this case, I think. It's one of the first things you mentioned to me. You got Darth Vader wearing the pin of the Rebels. So I don't want to say the guy's Darth Vader because I don't know this guy. And I'm sort of just joking about that. But, yeah, there's some irony there for sure.
Yeah. Last thing that it's, once again, completely irrelevant to our legal analysis of whether there was proper self-defense in this case. But I think it's worth saying something about the fact that this case became so racially charged, and that part has been confusing to some and very clear to others, right? I want to steelman the position of folks who are saying that this is a racial trial, right? Because these protests broke out in response to the shooting of Jacob Blake, and we don't need to hash out that whole case, but whether you believe the shooting was justified or not, that's why people were there. They were demonstrating, and so a lot of folks on the left, for example, saw that the people who Rittenhouse shot were allies, basically white allies of this black movement, movement for black citizens' equality to be treated fairly and reasonably by the police and the justice system. And I think Kyle Rittenhouse, for folks like that, really became more of a symbol, right? He's carrying around an AR-15, which is something we associate with maybe Trump supporters or people on the right, Republicans and things like that. And so I think it took a symbolic overtone to folks like that.
Yeah, I think there's no question about that. And I sort of reject the notion that because of the color of your skin, you have a right to be more outraged about how police treat black people. Or people of any minority. It doesn't matter to me. I don't care about that. I can't believe any reasonable, rational person would feel differently about how the police act based upon the color of the skin of the person the police are acting upon. We need to stop with this. Enough is enough with this. This isn't a black issue. It's not a white issue. Police brutality is an every person issue, right? We're against, like I say on many, many occasions, we are absolutely anti-bad cop and pro-good cop. To lump the cops all in the same bucket is absolutely outrageous, too. My experience is most cops are pretty good people trying to follow the law, which can be very complex. There are definitely some bad apples out there. We've gone after some.
And we love suing them.
We love suing them. We have one right now, the Wheatcroft case. If you want to see a bad actor, take a look at that video and judge for yourself what you see on that video. We are not afraid to go after bad cops. nor are we afraid to defend good cops when they're accused of crimes and they acted appropriately. So we should stop broad brushing people. We got to get past this issue of looking down, seeing what color the skin is of a person, and then making a judgment based on that. We're better than that.
Yeah, it's something I was saying, and obviously, notably, nothing that had to do with police brutality bears any relevance at all to our legal analysis of whether at the time that he pulled the trigger, Kyle Rittenhouse reasonably believed that he was in imminent fear of death or serious physical injury. But one of the comments that I'm seeing a lot of, and this might be true, it might be not true, the comment is, well, if he was black, if Rittenhouse was black, this trial would already be over. He'd have been found guilty. He'd been convicted. That would be the end of that. And this comment has been troubling me, and here's the reason why. What is intended by that comment is basically say, well, the justice system is really shitty for black people. The justice system is really shitty for black people. That's what they're saying. That's what they're intending to communicate with that comment. Now, let's grant them that. Let's grant that the justice system is really shitty, particularly for black people. I don't necessarily believe that, but let's grant it. If that's true, assuming that's true, then all you're saying is we're getting no justice for black people. It's really shitty. Let's make it shitty for everybody. Let's make it equally shitty for white people. Rather than a message of raising it up to proper standards, you're saying drag them all down to the lowest level of injustice that we're suffering. Is that really the right message here?
Look, we got to make a decision. Do we want a civilized society or not? If we want a civilized society, we need to act in a civilized way. We need to finally get to the post-racial point. We need to say, okay, look, there definitely was injustice. There's no question. There was racism. There was institutional racism. There was slavery. There was all kinds of bad stuff. This is not stuff that is unique to the American experience, right? Slavery didn't start in America. This is not to minimize the harm that happened in America from slavery, but just to be fair about it. It happened all over the world. The history of humans on the planet Earth is a history of tribalism and injustice and aggression, and one tribe beating up and murdering another tribe and stealing their stuff and taking their women. Human history is replete with injustice, and no matter what we do, we can't unwind all of that. Even if we wanted to and tried our very best, we can't unwind even 1% of that. We're not even aware of 1% of that. We got to get past it. Somehow, we have to look down and say, you know what? I'm going to really buy into what Dr. Martin Luther King Jr. said. Really think about that statement. Can we judge people by the content of their character and stop judging people by the color of their skin? We need to get past this stuff. And so I sure hope everybody, and I urge everybody else who's part of the justice system and is commenting on this case and all these cases going forward, let's just call it down. Let's call balls and strikes and not care about the color of somebody's skin or their ethnic background. Until we can do that, and I'm also calling on people outside the justice system to demand that balls and strikes are called and not use the criminal justice system as a political puppet or a political softball to kick around to make political points. There was a kid here named Kyle Rittenhouse, alleged to have done a lot of bad things, but he could be in prison for the rest of his life. And in a free country and in a civilized country, we give that person due process and a scrupulously fair trial, as fair as we can make it, to ensure we don't get that one wrong.
Yeah, I feel like in this case, to kind of put it like this, I feel like a lot of folks on the left, on the political left in this case, when reacting to this verdict, I feel like they were wrong for the right reasons. I feel like the law didn't shake out in a way that supported guilt or murder or anything like that, but the reasons that they were pursuing it is because they're interested in equal justice. They're interested in everybody being treated the same in the justice system. They're interested in equality between people. They're motivated by the best reasons in the world, and they happen to be wrong on the law. Whereas with folks on the right, I feel like many of the folks on the right reacting to this right now are right for the wrong reasons. They happen to be correct on the fact that just in a cold calculation there was justifiable self-defense here. But the reason is to own the libtards, to rub it in their face, to make sure they know they're going to cry. Leftist tears. They're going to cry and everything like that. Ha ha. Score 1 point for our team. So I think the left is wrong for the right reasons, and folks on the right are right for the wrong reasons.
Well, this is why we need to jettison both of those approaches.
Exactly.
And think about live and let live, right? Think about treating people properly, thinking about aspirational values. Let's just be good humans, right? Let's be open-minded, tolerant, kind, civilized. Let's care about a justice system that gets it right, regardless of what color you are or any of these other unimportant, immutable characteristics. And again, that's why a big part of the reason we're pushing live and let live, because we're tired of both sides up on a soapbox trying to make a point. And at the end of the day, both sides really aren't that different. They both are happy to boss you around. They're both happy to initiate force and to be aggressors against your body's property, money, and time. The only difference between the two is they're just bossing you around in different areas, right? The Republicans usually are at war with your civil liberties, and the Dems are usually at war with your economic liberties. How about we just take a position that you're in charge? You are the unapologetic, iron-fisted dictator of your own body, property, money, and time. Let's start there and draw a line down the middle and say, look, the only thing we care about is when one iron-fisted dictator is interfering with another iron-fisted dictator. That's what live and let live is about.
Very well put. And with that, we'll wrap it up. Go to liveandletlive.org to learn more about this movement and what we're all about. Watch this podcast and many more. And also get involved. There's lots of great ways to get involved there. You can join a chapter. You can start a chapter. You can see all the articles and post yourself. Get involved in the discussion. We've got an upcoming book. We've got upcoming events. A lot of exciting things going on. Don't sit idly. Be part of the solution, not the problem, and get involved.
Can't say it any better than that.
All right, fantastic. Well, my friends, this has been attorney Andy Marcantel and attorney Marc J. Victor. We're the Peace Radicals. Peace.